This has been something of a horror, I was going to say a horror year. Yes, it's been a horror year, hasn't it, for the Greens, who have been through a perambulations that I don't think would any political party in terms of the volume of, but certainly the per capita damage that's been done to that party would be, I couldn't think of a time in New Zealand politics would have been so extreme. They've lost a leader. He retired. They've lost somebody who died, sadly, at a recreational event. Mr. Collins, who would have, I think, done quite well for himself. They've got a co-leader who is currently suffering from cancer. They have Darlene Tana, who's just been expelled from Parliament by the Speaker, Jerry Brownlee, as you would have heard. And then yesterday, former Green MP, Golriz Ghahraman, was a sort of, they do, is it the final act of losing her appeal for a shoplifting spree that she went on prior to the election. It was an interesting case because Ghahraman, a lawyer, trained lawyer, who'd also served, ironically, as the Greens Justice spokeswoman, was convicted earlier this year in June by the District Court, fined $1,600, rather than being ordered to serve a custodial or supervision sentence. And in the Auckland District Court, Judge June Jealous, Jelas, denied her request to be discharged without conviction. And so she took that judgment from the District Court to the High Court, and in a judgment released yesterday morning, High Court Justice Geoffrey Venning said that the consequence of the conviction cannot be said to be out of all proportion to the gravity of offending in this case, meaning there was no error in the District Court decision, and that was the end of it. To get us to try and make sense of this, but also to understand how discharges without conviction work, and whether or not Golriz can ever really return to a respectable job as a consequence of these convictions, we're joined by one of New Zealand's leading defence lawyers, Marie Dyhrberg. She joins us now. Marie, lovely to see you again. And thank you for joining us on this issue.
Good morning, Michael. Pleased to be here.
Listen, one of the things that strikes me about, first of all, discharges without conviction, as somebody who has been discharged without conviction, can I say, for breaching apparently what did I do? Just trying to remember. I think it was contempt of court. I think that's what it was. And I was found guilty but discharged without conviction. So I've benefited from that. How many Kiwis sort of get discharged without conviction? And if they are discharged without conviction, and I don't believe the police oppose that in my case, why would the police bring it to court in the first place?
There are a number of factors relating to discharges without conviction. Many years ago, it was a lot easier to be discharged without conviction. They then brought in amendments to the law, so it made it tougher. And while sometimes it might seem to the public that the wealthy, the privileged, the sporting people, for them it's really easy, it actually, as a practicing lawyer, it is really, really hard to get a discharge without conviction, because what has to balance, in quite simple terms, you look at how serious was this offending, and then you look and need to then say, the consequences of a conviction have to be out of all proportion to the gravity. So the more serious the offending, the greater those real and appreciable risks have to be for the consequences. So that's where your balancing act goes. Now, people can get discharges without conviction in a variety of circumstances. One is that one of the areas of law that's really hard is that of deportation and visas, where the actual conviction itself triggers deportation. You might have people out there in the community, so they cannot have apprenticeships because it is absolute bar if you have a conviction. So you've got that group of people so that they have a strong case to make out and say, look, I'm young, it's relatively minor, and I can't pursue, my career or, supporting anything at all in terms of sport or other reasons. So you've got that category. The other interesting category that we have found within the therapeutic courts, and this goes back, of course, to what is good for trying to stop offending. So you might get somebody in, say, the family violence court, and sometimes the assault or the offending is not good, in terms of that. It's really, really bad. But they will take almost a year sometimes. They will go to CADS for alcohol training. They will do the Man Alive violence court. They will do work in the community, and that's the carrot and stick. So the therapeutic courts at the end of it will say, right, you've really stuck it out, you've turned your life around, your attitude, a lot of things have changed. Your reward is we will not blight the rest of your life. So that's another category where you might get a Section 106. So you've got those various categories, but your starting point is always how serious was the offending, and you've got to chip away to get it down to low after that.
Okay, I understand what you're saying. When did the law change come through, Marie? How long ago was that?
We've really been battling that for I would say about 15 years now. Where it's been.
So maybe I was just a bit lucky, was I? I think I was working at Radio Live. I was mayor, and I was working at Radio Live at the time. My mayoralty came to an end when I retired 2010. So I might have been under the old rules, was I?
Could be, because I belong to the school of thought that says unless like super at risk, everybody's entitled to a mistake. Put the clock back beforehand. We'll give you one chance, because convictions can be so devastating to your future. I would probably not last before they take me off the bench, because I'd give lots of discharge without conviction. However, they have to pay me a nice big retirement fee.
Well, listen, 3 strikes legislation coming up. It might be needed. Hey, so that's really interesting. It's got to be serious consequences, and you've just given the example of apprenticeship or somebody at the start of a sporting career, or somebody who's been through self-rehab. So you can see that the courts can see that they're actually making a real attempt to change their lives around, and they've gone through it, which is fine. I get that. But in this particular case, Golriz Ghahraman, and forget the wealthy privilege side of this, but just looking at the questions or the issues that you've done, she could argue, couldn't she, that the convictions are going to harm her professional career as a lawyer, number one, and number two, they also her lawyer put before the court this idea of suffering from a clear diagnosis of complex post-traumatic stress disorder, and citing relative evidence around that. Now, obviously, neither of those worked with either judge. Why not? Because the actual qualification has to be quite rigid and quite strong. So, say in this particular case, where it said this is going to affect her career, if, for example, the result would be of a conviction that she could never get a practicing certificate again, then that's where you go back in almost that deportation area where that's it, no discretion, and you are completely ruined for the rest of your life. But in reality here, the Law Society will not be it will take into account and say, look, you got a conviction. But the main thrust of the Law Society assessment is going to be, what is your conduct? What did you do? And it's a very high character bar that lawyers must qualify for, because if you can't trust a lawyer,
then who can you trust? So you are looking.
Oh, don't make me answer that question.
I'm giving you some good.
Yeah.
But honesty is very high for a lawyer, and
Yes.
what the court said in this case was the Law Society is going to look in the whole realm. It's going to look at everything, and that's exactly what the Law Society will be doing. So it's not the conviction that will bar her from proceeding. In a lot of ways, it's they're looking at the offending and saying, well, what really is this offending? Is this somebody who has good enough character or good enough reason to actually practice as a lawyer? The second thing that you mentioned, Michael, was the mental health issue. Now, sometimes mental health or drug dependency or alcoholism, those sorts of things, they can contribute to offending. They can make you a bit more liable, a bit more vulnerable to offend, but they don't actually cause you to offend. But if, for example, you had a mental health issue and your mental health issue was such that you lashed out or you suffered from fetal alcohol, so you were impulsive in a lot of things that you did, you could say that those conditions are causative of you behaving in a particular way. In this particular case, the trauma, the post-traumatic stress disorder, the court found that did not contribute, and it was not causative of the offending. And of course, the defendant herself provided a report, a psychiatric report, but that report did not go far enough. It was equivocal. So had you a report that was very clear, independent evidence to say this offending was caused by this mental health disorder, then you're thinking of something and you're a whole different ballgame. But even the defence psychiatrist did not go that far. So you don't have that evidence.